Good morning, everyone. Thanks for your time and your support, and every time you are joining us, and everyone is appreciating our efforts, and especially our panelists, their knowledge sharing. We thanks all the participants and our all panelists. And also now today's topic in our webinar on masterclass on issue of securities. Today's topic is an insight into issue of debt security. And today, our presenter is Ms. Alifia Sapatwala, partner Mehta and Mehta. And we have with our panelist, Ms. Deepika Thakur Chauhan. Ms. Deepika Thakur Chauhan, let's introduce our presenter, Ms. Alifia Sapatwala. She is an associate member of ICSI and also commerce and law graduate from Mumbai University. She possesses around 10 years of experience in the corporate secretarial and legal field. She specializes in listing, FEMA, and NBFC compliance and has been handling compliances under various corporate laws for both listed and unlisted companies. We have as panelist, Ms. Deepika Thakur Chauhan. Ms. Deepika Thakur Chauhan is a law graduate from Osmania University, Hyderabad, with strong academic achievements, holding 3 gold medals, my goodness, from the academy. She is a qualified company secretary and CA Inter, holds membership with Institute of Company Secretary of India, has over 17 plus years of experience, of which 10 years with BFSI sector, has been associated with Essel Group, Abexcas, Stream Global Services, and Time Leading their compliance function, was also associated with industry body, Internet and Mobile Association of India, and its arm Payment Council, in their efforts for creating framework document and risk assessment methodology for prepayment instrument issuers. Welcome, Deepika.
Thanks a lot, ma'am.
Currently, she is working as a Chief Compliance Officer, Company Secretary, and Head Legal of Oxilo Fine Service Private Limited. Oxilo is an NBFC promoted by Enam Group with Berlampur Chini Mills Limited, ICICI Bank, and Tata Capital Growth Fund as its prime investors. She joined Oxilo Fin Services Private Limited as a startup and set up a legal and compliance function of the company. Thanks a lot, Deepika, for your time. Wonderful experience. We would like to hear from you. Of course, as usual, our Mr. Bala is there with us, moderator. You know everyone. Friends, today's topic is that of issue of debentures, means raising the debt fund. We have discussed a lot about equity, but today we are talking about debt because that itself is also another way of raising the fund. As everyone knows that earlier listed debt listing was not so common, but government wanted the debt debt market to have deepened, so they promoted listing. Oh, initially, surely it was as promised, the compliance was not that as equity listing, but slowly and steadily it increased and it's still increasing. And hence one has to understand the listing requirement and compliances of debt security as well. So we have with us, of course, experienced Ms. Deepika, who has listed debt securities, and also our experienced partner who has done this issue of debentures. So with both, and our own Bala with his own experience. Friends, today Sudhakar is not there because he has family function and he has regretted and apologized for his absence. So, but let's start with today's webinar. I'll request Ms. Deepika to say a few words on the topic, and then Mr. Bala, and then Alifia, you can start. Over to Deepika, please.
Sure. As ma'am rightly pointed out, as against equity listing, debt listing was not something that was primarily, I think, was that regulated or recognized. But of late, debenture is one of the most opted for way of raising capital, especially in the BFSI sector where, the money is a raw material for them. Debentures is one of the most important source of raising funds. And while we talk about the masterclass today, we'll hear it from Alifia as to what all compliances and what all regulations apply here. But I just thought as a preface, I'll talk about basics here. We all know debentures is more of a debt. It's a security where you're borrowing funds. And every feature that applies to a term loan, let's say you're paying the interest on a regular basis and then repaying your entire principal. And what anyone who's lending you money will look at getting the right security. And all the regulators who are associated here, be it your ROC, the stock exchange, or the SEBI, they've framed the regulations, or for that matter, company law, within two specific sections of Section 17 and Rule number 18 of Share Capital and Debenture Rules. They've consolidated all of the requirements under these two specific sections by talking about the fact that how investor security can be ensured. That is, bring in the requisite amount of security, file your charge form, inform the stock exchange about your interest rate payment dates or your prepayment dates. Once you've been paid the interest, inform the stock exchange again so that there is requisite information disseminated. Now, I think to my understanding, these are the very prime factors or this is where the entire regulations revolves around. But specifics, we'll hear it more from Alifia and insights from Balakrishnan sir and Dipti ma'am. With this, I think I'll pass it on to Dipti ma'am and sir again.
Good morning to all of you. I have a great pleasure in welcoming you all for yet another interesting topic of the debt listing. As our earlier Dipti and Deepika said about the various regulation, importance, etc., and all this thing, I won't talk about all those things. But only thing in the recent past, if you all notice, debt listing is becoming very, very important because raising capital via debt actually is becoming more accessible towards the investor by the company. That is one thing. Because compared to IPO, FPO, and other thing, and debt raising is becoming little easier. That is number one. Number two is that if the debt securities are listed, then again what it happens is for the companies, it is very much facilitated to earn their reputation, and as well as it is easier for the investors to trade the things, etc. And the next thing is it also gives you what you call the sort of a fixed income in the form of the interest. Again, coming to the business, again what happens is the interest paid on the debentures is actually tax deductible, which is not the case in case of the fundraising through the IPO, FPO, etc., where it is actually appropriation to the profit. These are the various things which are actually there, but at the same time, the regulators are looking into the securities and safeguarding the interest. We will go through the nitty-gritties because since we have two experts, one is actually virtually handle the debt listing, other one is actually dealing with the expert field. We will more to hear from them. With this, I give a pause here. I'll ask to take a presentation over this.
Yeah, Alifia, you can start, please.
Good morning, panelists, and good morning to all my professional colleagues. So here we are bringing with you a masterclass on issue of security, and today specifically we'll be giving an insight into the issue of debt security. I'm Alifia Sapatwala, and I am a partner at Mehta and Mehta, Volita. So as we know, the issuance of debt securities includes debentures and bonds. It's a pivotal process in the corporate financing structure. So companies resort to issuing debentures and bonds for raising funds. These are primarily governed by the Companies Act and various other statutory regulations, and to safeguard primarily the investors who are investing in such debentures and bonds, and to enable corporate entities who are raising such funds to maintain transparency and legal compliance. This presentation will give a comprehensive overview of the legal provisions that are governing the issue of debt securities. It will also examine the key aspects such as creation of security interest, the role of debenture trustees, establishment of redemption reserve, and the requirements that are required for under applicable regulations. So what are debt securities? These are financial instruments. They are issued by the companies, governments, or entities who are intending to raise capital. These securities represent a loan made by an investor to the issuer who is obligated to pay the principal amount along with the interest over a specified period. These are basically determined as and pre-decided as terms to the issuer. In a sense, debt securities are a way for issuers to borrow funds from the investor. These are the types of debt securities. So we can issue bonds, debentures, treasury bills, zero coupon bonds, commercial papers, promissory notes, medium-term notes, asset-backed securities, collateralized debt obligations, and securities, whether convertible or non-convertible. The legal regulations which are applicable to issuance of debt securities are Section 71 of the Companies Act 2013, which is read along with Rule 80 of Companies Share Capital and Debenture Rules 2014. We have SEBI Issue and Listing of Non-Convertible Securities Regulations 2021. Companies also need to comply SEBI Issue of Capital and Disclosure Requirement Regulations 2018. Disclosure requirements have been specified under Chapter 5 of SEBI LODR Regulations 2015, and we have our RBI Master Directions 2024 relating to commercial papers and non-convertible debentures. So, through this presentation, I will take you with each of the regulations in brief. So, Section 71 of the Companies Act. They primarily talk about convertible debentures, which provides that a company can issue debentures with an option to convert them into shares, whether wholly or partially, at the time of redemption. However, such issuance shall also be approved by the shareholders of the company as a special resolution at its general meeting. An important feature of debentures is this: they do not carry any voting right for its holder. The secured debentures, which may be issued by the company, are issued at prescribed terms and conditions, and the date of its redemption shall not exceed more than 10 years. However, there are exceptions where companies engaged in a particular sector are allowed to issue debentures for up to 20 years. In respect of secured debentures, charge needs to be created on the company's asset. The company's asset needs to provide a proper 100% security cover for the same. Section 71 also provides for the companies to create a debenture redemption reserve from the profits of the company, and these reserves can only be utilized for redeeming the debenture. The companies also need to appoint one or more debenture trustees if they are offering such debentures to the public or to people exceeding 500. Such debenture trustees are appointed to protect the interests of the debenture holders and to also address their grievances. Any provision in a trust deed which is exempting the trustee from liability for breach of trust is void unless agreed upon by a majority, 3/4 in value of the debenture holder. Section 71 also throws light on the payment and redemption of such debentures. It specifically provides that a company must pay interest and redeem debentures in accordance with the issue. If a debenture trustee believes that the assets of the company are not sufficient to pay off the debentures, then it may file a petition before the NCLT to impose restrictions on further liability. If a company fails to redeem or pay interest on such debentures, the tribunal can order the company to do so immediately. Section 71 is always read with Rule 18 of the company's share capital and debenture.
1 minute, Alifia.
Yes.
Even there are many cases where debenture trustee has filed the cases under IBC for the companies. Just for adding. Thanks. Go ahead.
So as we understand, Rule 18 of the company's share capital and debenture rules provide the detailed guidelines of the compliances which a company needs to do in respect of the issue of debentures. So, secured debentures cannot have a redemption period exceeding 10 years except for infrastructure companies and specified NBFCs which can issue them up to 30 years. The debentures must be secured by creating a charge on the assets of the company, and such cover should be sufficient to cover their repayment. The appointment of debenture trustee before the issuance of prospectus is very essential, and a trust deed needs to be executed within 60 days of the allotment of such debenture. The trustees must not have any conflict of interest, such as they should not be the shareholders, cannot occupy KMP positions, or have any financial ties with the company issuing the debenture. Some of the duties of the debenture trustees are to ensure compliance with issue terms and protect debenture holders' interests, monitor company performance and report defaults, and appoint a nominee director if the company defaults on payment, security creation, or redemption. Further, the rules also provide for holding the meetings of the debenture holders upon any written request received from at least 10% of such holders or in case of default in the or breach of its terms. The trust deed shall be executed in the prescribed form SH12 within 3 months of the issue close. Debenture redemption reserve and investment requirements have been prescribed under Rule 18, which states that DRR must be created from the profits of the company, and specified financial institutions and NBFCs are
Alifia,
exempted from creation of DRR.
Alifia, go a little slow, please.
Okay. Okay, ma'am. It also provides companies must invest up to 15% of debentures maturing during a year in approved securities or deposits by April 30th of that year. The trust deed must provide for inspection of the copies to the members or debenture holders on the request. The Rule 18 provides specific exemptions for instruments such as commercial papers, foreign currency bonds, and rupee-denominated bonds issued to overseas investors. So, Deepika, can you throw a light on the importance of debenture trustees, which has been covered under Rule 18?
So, Alifia, I actually wanted to take an opportunity to talk a couple of points under Rule 18. One was, if we can move to slide number 7, just the slide before this, where you actually mentioned very categorically under point number 3, where you said the appointment of a nominee director if the company defaults on payment, security creation, or redemption is something which falls under the duty of the debenture trustees. Here, I just wanted to bring to everybody's attention, and I'm sure our fellow colleagues who are company secretaries would have noted the importance of this specific point when SEBI mandated under its regulations for all the companies who are planning to have the debentures issued or who have got the debentures issued to modify their articles of association. And there was a specific deadline that was provided to the companies in order to modify the articles. Now, debenture trustees' role is extremely important. And like I said, I find it very interesting to understand the entire gamut of regulations within Section 71 and Rule 18, where it covers everything that a professional should know when the debentures are to be issued. Specifically, when it comes to debenture trustees, you are required to have a debenture trustee, to be signed, which is an important document of the entire transaction, where you have to make sure that everything that is mentioned under Section 18 are incorporated under the transaction documents. And I was just wanting you to take note of the fact that, in case these are not amended under your articles of association, an enabling point should be added that debenture trustee should have an authority to appoint a nominee director. And of course, that's event based. That is, if you are getting into default, that's when the debenture trustee gets the right to appoint a nominee director. So just wanted to highlight this point. We can move to the next slide, Alifia.
Thank you.
Over here again, I think the slide very broadly covers very importantly. I mean, all the important points have been very nicely covered. However, just wanted to talk a little bit about the debenture redemption reserve. This again is a very important point in the entire gamut of the regulations. It's important that, when you are raising funds, you should be in a position to pay off the interest and the principal on time, and hence a DRR kind of takes care of that. But there are certain entities to whom the DRR is exempted. Now, me being from financial sector for a very long time, I wanted to again highlight this bit that for an NBFC or all India financial institutions, be it banks or the entities which are actually categorized as AIFIs, listed NBFCs, HFCs, all of these entities are actually, they enjoy the exemption from creation of the debenture redemption reserve. So just wanted to, I mean, just in case any one of you are planning to issue debentures or an NBFC or fall under these categories, then DRR is something that's exempted. So yeah, I just wanted to highlight this bit. Alifia, over to you.
Thank you. So now we take forward the presentation and take into account the regulations, NCS regulations as they are famously called as. So this regulation consolidates and streamlines all the provisions relating to issuance and listing of non-convertible debentures and non-convertible redeemable preference shares. So this provision.
One more thing is there when you are talking about the debenture redemption reserve. Debenture redemption reserve can only be created out of the profits earned by the company which are available for distribution. It cannot be created from any other source. That is another important thing which is actually there to be noted. Yeah, go ahead.
So NCS regulations, they are applicable to public issue and private placement of non-convertible securities, public issue and listing of non-convertible redeemable preference shares, and listing of NCDs on recognized stock exchanges. It also provides the eligibility criteria for the issuer, where it states that the issuer must be a company, body corporate, a statutory corporation, or a REIT or an InvIT. It also specifies the minimum credit requirement that is required for public issue of such securities. The issuer must have complied with LODR regulations for these listed securities, and he should not have defaulted in the payment of interest or repayment of the principal during the last 3 financial years. The issuance of such debt securities are categorized into 2 categories. They are public issue and private placement of these debt securities. Public issue of debt securities requires a company to file a prospectus with the SEBI and the exchanges. The minimum subscription has to be 75% of the base issue size. It requires mandatory listing within 6 working days from the closure of the issue, and advertisement in the newspapers are required to be made before such issue begins. Private placement of debt securities, as it provides mandates, offer to maximum 200 investors per financial year, and such a number of investors exclude QID. It requires disclosure documents instead of a full prospectus, as in the case of a public issue. Securities are issued through EBP, electronic book mechanism, for issue size exceeding 100 crores. And the listing of such securities needs to be done within 4 working days from the closure of the issue. The disclosure requirements that go along with under the NCS regulations are: the financial statements are required for the past 3 years. The companies need to mention the purpose of such issue, the terms of redemption, and the interest payment date. The debenture trustees executed with the debenture trustee, and the details of the creation of the asset cover or security cover for such issuance is required to be mentioned. The details of the credit rating assigned by the SEBI registered credit rating agencies also needs to be disclosed at the time of issue of such debenture. The regulations pertaining to credit rating requirements state that the issuer must obtain a credit rating from at least one of the SEBI registered credit rating agencies. If the issue is via public offering, then ratings from at least 2 rating agencies will be required, and such ratings need to be reviewed at least once a year. In case of secured debt securities, the appointment of a debenture trustee has been mandated by the NCS regulation. Such a debenture trustee needs to be registered with SEBI and independent of the issuer. He is responsible for protecting investors' interests and ensuring compliance with terms of issuance. Regarding security creation, the issuer must create a charge on the assets to secure such debentures, and such a charge needs to be registered with a ROC and certified. The issuer of such debt securities also needs to comply with continuous disclosure requirements with the exchanges and SEBI. They need to submit their annual and half-yearly financial results. The credit rating updates and defaults, if any, needs to be disclosed timely. Any change in the board of directors or any corporate action that may affect the rights of the debenture holders needs to be disclosed to the exchanges. Deepika, you need to throw any insight on the NCS regulations, then we move forward to ICDR.
So I think, Alifia, I'll not take a lot of time, just a quick minute here. NCS regulations, as you all know, has got operationalized recently. And now they've mandated to have a general information document and key information document. Now, this is one of the very important takeaways for the professionals who are actually into the process of issuance. Now, we practically, what we as a process make sure at the start of the year is to ensure that there is a borrowing plan in place for the company. Typically, again, it differs from company to company. However, like I said, for NBFC sector or the financial services sector, where money itself is a raw material, it's very important that they plan beforehand. And we are also guided by the RBI regulations. Now, RBI regulations mandate the company to have a resource planning done right in the beginning of the year, which means we are required to have the board approvals in place. I'll just take a quick minute. I'll not prolong over here. But then in terms of planning, when you look at RBI regulations or the NCS regulations, what we can do in case there's a planning in place and we are able to achieve that, if you as a professional can make sure there's a checklist of borrowing plan being approved, your resource planning being approved, which should have what kind of NCDs or the debentures are to be issued, followed by having a shareholders approval in place for a blanket approval and a GID. Now, GID is an important document that you will have to have akin to a prospectus, where you're talking about all your risk factors, details of your company. It's an extremely elaborate document, which you file with the stock exchange, followed by whenever you're making an issuance of NCD, you have to have a KID in place. KID is a key information document with respect to any smaller changes that may have happened in the company. And now you're raising the capital. So you give that kind of information in your KID. Otherwise, there's a big checklist which you should always have in place. Look to your NCS regulations once and have that checklist in place. Broadly, Alifia kind of gave a synopsis of it very beautifully as to what all information and consents, appointment of the RTA, appointment of the trustee, consent, etc. should be taken. So I think very nicely covered. That's it from me, Alifia. I think you can take it ahead from me.
I would also like to highlight, Deepika, here that SEBI has been very categorically in NCS regulations provided format of each and every disclosure the company needs to make, so that there is no, you can say, the absence of information for the investor who might be investing in such debt securities. So companies need to follow NCS regulations precisely and accordingly to comply with the regulations.
Very true. The formats really kind of come for our rescue as well. We know what we have to really write. There's no too much of thinking there. So yeah, rightly pointed out, Alifia.
As Deepika said, and good amount of the planning, etc. One of the important point one should not miss out is actually the pre-approval of the debt listing before the issue opening date. That is very important, because if you have seen, she has already listed them within 4 days, within 7 days listing. Unless you have the pre-approval done before the issue of opening date, then it will be very difficult. That one should not miss out, actually, which I would like to add. Yeah.
Correct, sir. Absolutely.
We move forward to SEBI Issue of Capital and Disclosure Requirements Regulations 2018. So these
one minute. Somebody is
Yes.
actually asking a question. What are the nominee director role over and above the debenture trustee? Is it already specified already?
Is that a question, sir? Sorry.
Yeah, that's a question. Somebody wants to know, what are the nominee directors' role over and above the debenture trustee? Is it specified already? That's a question somebody is asking.
So at a very broader level, and sir, you can elaborate it, and Dipti ma'am, if you want to add further. Now, in my experience as a professional, I've seen these kind of rights are always retained by even a banker who's giving you a very huge loan, let's suppose. Even under a term loan, they would want a favorable covenant written that in case the company is defaulting or goes into some kind of issue, they should have the right to have a nominee director appointed. Same goes with the investors, normal investors who are investing into your equity. Similarly, over here as well, what's really happening is the debenture trustee has been given a right to appoint a nominee director, such that somebody is sitting on the board and monitoring as to how the business decisions are being taken. That's basically the reason why a nominee director is appointed. Debenture trustee otherwise is monitoring the entire issue by looking at the transaction documents, ensuring that all the covenants that have been agreed under the transaction is being completed or no, whether the interest is being paid on time or no. All those checklists which is mentioned under the section 71, is something the debenture trustee looks at. But nominee director is somebody who's getting a seat on the board and is able to look at the governance of the board and see how the business decisions are being taken. And therefore, the interest of debenture holders that ways is taken care. That's my take on having a nominee director on the board. Any views, Balkrishnan sir?
Yes, absolutely. You're touching upon the point. In fact, I remember way back 30, 40 years back when people used to go to financial institutions and the bank, there is always a case like what you said, a covenant, not only the covenant, there is actually a requirement. A nominee director will be appointed from the bankers or financial institution to represent the board. Generally, what they do, they wanted to take care of the interest of the borrower. That means people who are given the money. So that means before you, because since you're sitting in the board, what happens is at the time of the declaration, the dividend, and this is the allocation of the funds, etc., and all the thing, they want to ensure whether the company is in a position to repay the interest and as well as the principal amount as per the terms of the condition, and you don't overspend by backtracking this. This is the interest. The same thing in case of the debenture trustee, because debenture trustee is not going to be on the board. The person who is sitting as a director, he will be in a position to know what is the insight, what is the decision we are taking to safeguard the interest. That is the whole purpose. You rightly touch upon the point here, actually. Yeah.
Thank you. Yeah, Alexia, you can go ahead.
So the SEBI ICDR regulations primarily govern the issuance of equity securities and the convertible securities. They apply to convertible securities such as fully or partly convertible debentures, convertible preference shares, and compulsorily convertible debentures. These securities are considered equity-linked instruments and they are regulated under ICDR because they are primarily converted into equity shares at a later stage. So ICDR Regulation 9 provides the eligibility for the issue of convertible debt securities. The issuer who is issuing such securities need not have a prior equity IPO. So even it provides an issuer who is which is a private company, can definitely list its convertible debt securities on the debt exchange. It should also not have defaulted in the interest payment or principal prepayment on public debt instruments for more than 6 months. Regulation 10 provides for additional requirements for such an issue. An issuer needs to obtain a credit rating from at least one credit rating agency, and it needs to appoint one debenture trustee as per the Companies Act and SEBI Debenture Trustee Regulation. The issuer also needs to create a debenture redemption reserve as has been already discussed under the Companies Act 2013. Further, it needs to ensure that secured convertible debt instruments meet security requirements, that is, they are free from encumbrance, it has sufficient asset cover, prior lender consent for second or pari passu charge, and etc. Regulation 11 provides for conversion of optionally convertible debt instruments into equity. Such a conversion requires positive consent from the holders of the debt securities, and non-receipt of a response does not imply that they have consented. If the convertible portion exceeds rupees 10 crores and no conversion price has been fixed at the time of this issue, the holder must not be given the option not to convert. If an option is given and not exercised, the issuer must redeem such unconverted portion within 1 month at a price not below the face value of the instrument. If redemption terms are already discussed in the offer document, the above provisions of Regulation 11 shall not apply to an issue. Regulation 12 provides for restriction on the use of convertible debt instruments. Such instruments need not be issued for financing, lending, or acquiring shares of promoter group companies. An exception has been provided for such debt instruments with a conversion period of less than 18 months, then they can be used for such purpose. These are some of the common compliances for issuance of debt securities, maybe through rights issue or further issue of shares under the ICDR regulations. All the specified securities held by the promoters need to be in the dematerialized form prior to filing of the offer document. The issuer must not have defaulted in the payment of interest or principal repayment during the last 3 financial years. No regulatory action should be pending against the issuer, and they should have complied with LODR regulations and Companies Act provisions. An offer document needs to be filed with the SEBI for public issues, and for private placement, an information memorandum needs to be submitted. A minimum investment grade rating is also required to be obtained from at least one SEBI registered credit rating agency. A lead merchant banker needs to conduct a due diligence and submit a due diligence certificate. A registered debenture trustee needs to be appointed before the issuance, and a debenture trustee must be executed. Debt securities listed on a recognized stock exchange need to follow the continuous disclosure requirements as per LODR regulations. Pricing should be determined based on market factors, and allotment needs to be completed within 6 working days from the issuance of closure. The issuer must ensure that the funds raised are used only for the purposes disclosed in the prospectus or the information memorandum. Any delay or default in payment of interest or principal needs to be disclosed to the exchanges. So these, in a nutshell, provide all the compliances required to be done by an issuer of debt securities under ICDR regulation. Deepika, or Bala sir, anything you want to highlight in this in these points?
I think, Alifia, you've comprehensively covered nothing from my end.
Yeah, I think you have comprehensively covered everything actually here. There's nothing. You have not left out anything for us. Yeah.
So Regulation 106 provides for FPO of convertible debt instruments. It provides that an issuer can make further public offer of convertible debt instruments if the equity shares are already listed. It must not have defaulted in the interest payment or principal repayment for over 6 months for previously issued debt instruments. So time and again we come to this point that there not has to be any default on the part of the issuer for payment, interest payment or principal repayment. This is a very important point which has been highlighted throughout the regulations. Here we have provided a comparative of ICDR regulations and NCS regulations. ICDR regulations, they are applicable to convertible debt securities, whereas NCS become applicable to non-convertible debt securities. The regulatory focus is primarily on equity-linked instruments under ICDR, whereas NCS regulations govern pure debt instruments. The minimum subscription for such securities needs to be 90% of the issue size, whereas in the NCS regulation it is 75%. The pricing mechanism has been market linked. For NCS regulations, it is a fixed yield-based price. ICDR regulations also comprehensively provide for lock-in requirements for the promoter, whereas no such lock-in requirements have been prescribed under NCS regulation. So, Bala sir, we understand that both these regulations are exactly opposite of each other, whereas one provides for compliance for non-convertible securities, the other one is for convertible securities. So
Yeah,
both go
right. Somebody is raising a question. If there is no profit in a particular year, and the company is not able to create DRR, what are the consequences? That is the question they are asking actually. It is very simple because the profit is not there, in which case the DRR not required to be created in that particular year. That is one thing, because it's very clearly said, this is from the company's available profit. If the profit is not available, that particular year, you cannot create, you need not create the things. Am I correct, Deepika, my understanding?
Slightly different view, sir.
Yeah.
I was under an impression, I mean, this is the understanding that I carry, but I would be happy to be corrected. I thought this is one of the preconditions. At the time of issuance, you are required to have this in place. In terms of eligibilities, that I am raising a certain amount and I will have to, at the end of the year, maintain the DRR. If that kind of a position we don't have, then I think from an eligibility perspective, we are kind of
you are absolutely right, because what happens is when it comes here, the companies which are not making adequate profit, they will not become eligible at all to issue the DRR. Sorry, debenture. That is the first point actually to start with. But the thing is, when everything goes well, planning, because ultimately everything depends upon what is the economy, how it is the growth, or what are the circumstances. Maybe after 2 or 3 years, sometime like that, the things goes bad. The company is not in a position to make a profit. That is the situation probably. If that is the situation actually comes, according to me, my understanding is, if a particular year the profit is not there, then I think there is no need to create a DRR because it has to be created only by the profit. That is the point.
Makes sense.
Yeah.
Thank you, sir. I agree on that, understanding. Yes.
Yeah. Yes, go ahead, Afia.
So we move forward to SEBI listing obligations and disclosure requirement regulations. Chapter 5 of the LODR regulations provide for extensive disclosures to be made by the companies or entities making listed securities. So they apply to listed entities that have listed their non-convertible securities on a recognized stock exchange, and the relevant compliances to be made under NCS regulation. A prior notice of at least 2 working days before the board meeting needs to be done for such issuance. Intimation on dispatch of notices also requires to be done for dispatch of notices pertaining to any meetings of the shareholders or the board. Such disclosures need to be in the mandatory XBRL format provided by the SEBI. Further, Regulation 51 provides for disclosure of price-sensitive information. So, immediate disclosure of any material event that may affect the performance of the company or the prices of the security, or any repayment of principal, payment of interest or dividends needs to be disclosed to the exchange. Such a disclosure needs to be made as soon as possible, but not later than 24 hours. So a company needs to apply make the necessary disclosure as soon as possible. And the information pertaining to such disclosures needs to be hosted on the website of the company for a period of 5 years. A host of other compliances are also required to be done by entities who have listed their non-convertible securities, and they are quarterly. They need to submit their unaudited financial results along with the limited review report within 45 days from the end of the quarter. Annually, entities need to submit the financial results within 60 days from the end of the financial year, and such results also need to be submitted to the debenture trustee. For approval and publication, the Regulation 52 provides that quarterly unaudited results must have a limited review report from the auditors, and such results needs to be approved by the board of directors. They need to be signed by the chairperson, MD, or whole-time director of the company. Annual results follow the same format. So the SEBI has categorically provided a format in which the disclosures need to be provided by the listed entity. Accordingly, such results have to be there in the same format. There are certain other disclosures which needs to be made by the entities along with the financial results. They pertain to debt equity ratio, DSCR, ICDR, net worth of the company, profit after tax, earnings per share, and other financial metrics as may be required by the SEBI. Annual audit reports should also include a statement on impact of audit qualifications if a modified opinion has been provided by the statutory audit. Regulation 52 further provides that in case a company has listed its redeemable preference shares, then additional disclosures are required pertaining to free reserve, securities premium, dividend payment history, covenant breaches, and funding plans for redemption by the listed entity. For non-convertible securities, entities need to disclose utilization of funds raised from such securities until they are fully utilized. Any material deviation from the usage of the fund needs to be disclosed to the exchange. The financial results need to be submitted or published in the newspaper within 2 working days of the meeting of the board. Further, an option for QR code-based publication has been provided to the entities subject to approval from the debenture trustee. So, Deepika, we understand that a comprehensive list of disclosures have been provided under LODR regulations for listed NCDs. So, financial results are one important such disclosures that an entity provides. Do you have any important point that you may have experienced at the time of disclosure being made?
So other than the annual report, Alifia, as you were rightly pointing out on all the, you again summarized the quarterly, annual and the disclosures that the company is required to make, even with respect to utilization of the proceeds you receive from the debenture issuance. I just thought I'll highlight the fact that the utilization of proceeds is something we're also required to place before the audit committee, and people who are planning to have the debentures issued or who are currently issuing have to make sure that it is placed before the audit committee on a quarterly basis. Now, I have very practically faced this question every time this is placed. Other than the audit committee members, if I have any other board member attending it, they always have this question as to why are you bringing it to us? And is this essential? Who's confirming it to us? Whether the utilization has happened in the way that was mentioned under the offer document. And either the management confirms it through the CFO's certification, or at times the audit committee expects an external auditor, secretarial auditor, or a statutory auditor to confirm the fact that the funds have been used only for the purposes that it was mentioned under the offer document. So I just wanted to take a moment and talk about this point, which was there in your previous slide. Other than that, I think the standard intimations that has to go to the stock exchange were very nicely and correctly summarized. Easy for anyone to understand that, you know, as you're approaching the quarter end, prepare yourself for publishing the newspaper the financials, and there is an LODR format which is provided under the SEBI regulations again for the publishing of the financial results. Now that it has become QR-based code. QR-based publishing, again, that has kind of aced everybody's work. So yeah, I think that is something that I wanted to just place attention on. With respect to annual report disclosures, yeah, again, this is, again, I think we can move to that third slide from here. As you've summarized. This is more to do with you working in tandem with the statutory auditors and your finance peers in the organization, making specific mentions under the director's report. For us, some of this information is to be mentioned as per the RBI regulations also. So while we look at SEBI regulations, we also make sure that the director's report covers necessary points with respect to the NCDs under the director's report as well. I think that's all I had to add over here.
Because somebody is asking a different questions actually, more or less. What they are saying is, when raising the funds, either through the preference or through the debenture or through the bonds, what will be my decision in making metrics? In fact, I think this question we will not be able to answer, because this question definitely depends upon the amount of the planning, what is the company's position, how they are actually placed with what cost it is going to cost compared to the pricing. Because when you talk about the preference and etc., that involve a lot of time, and also it involves a lot of cost, etc. While compared to the debt funds, it will be easier. The company has to take a call while planning side. That's what I would think actually. Because there cannot be a, yeah.
No, I completely agree, sir. Sorry, I interrupted you. I think,
please, no. I only said there cannot be a standard metrics what need to be done, what is the thing, etc. Because much will depend upon the circumstances of the company in which they have placed what they are planning to do. That's what I think actually. Yeah.
Absolutely, sir. Again, as we see it, I think again we've learned it from under our basics that raising of preference shares or debentures also goes with the philosophy of the investor. For an equity investor, somebody who's ready to take a risk, put in the funds and wait for gradual income to come in is an equity investor. For us, in terms of compliance cost or the funds raising cost, relatively, as you rightly said, is the debentures that can be raised quickly. And again, preference shares has their own categories, redeemable preference shares, non-redeemable preference shares. Again, they have their own features and attracts that kind of set of investors. In terms of expenditure or the compliance cost, I think debt really comes very handy. And for your working capital expenses or your immediate needs, I think debenture kind of has helped a lot of organizations in their fund requirements. That's my take, sir. But as you rightly said, we cannot define a matrix. Really depends on person.
Yeah, that is right. Not only that, there are a lot of things because when you are going for the what you call capital raising through the IPO route, FPO route, and preference route, etc., these are all involve what you call the payment of the dividend, which is actually not tax deductible. It will actually go as a appropriation from the profits actually. But at the same time, when it's come to the debt funds, it actually goes in the form of the interest, which is actually chargeable to the profit and loss account. You get the tax benefit as well. So there are a lot of things which need to be actually considered while actually making a decision. That's what I thought I should bring it. Yep. Somebody is asking, do we need a registered valuers report for issuing the non-convertible debenture?
To my understanding, no, the registered valuers report is not required for debentures, but I think Alifia is rightly placed to confirm that.
No, it is not required to be done. It is only for equity instruments. For debentures, the companies have the proper authority to price them as per their requirement.
It is non-convertible. That is to be.
Yes.
Somebody is asking if the unsecured debentures are not listed, it is considered as a deposits. What are the provisions that need to be complied with that case?
So unsecured debentures needs to be listed unless they are secured debentures.
Yeah.
Or else they will attract the deposit fee. It has been rightly called.
So rightly mentioned that if unsecured debentures are not listed, it will attract as a deposits pool as well. Right?
Yes.
Yeah. Okay, go ahead.
So Regulation 53 provides for annual report disclosures, audited financial statements, cash flow statements, auditor's report, director's report, the details of the debenture trustee, and related party disclosures, which are required to be mentioned in an annual report of an entity which is listed as non-convertible debenture. Such annual report also needs to be submitted to the stock exchanges, debenture trustees, and needs to be hosted on the website of the company. Any changes in the annual report needs to be informed to the exchanges within 48 hours of the ED. Regulation 54 categorically provides for security cover for such secured listed non-convertible debt. So a company is required to maintain 100% security cover or even a higher risk as per the terms of the offer document or the trust deed. Quarterly disclosures needs to be maintained on needs to be provided on the extent and nature of such security which has been charged. Disclosure of the security cover status along with the financial results in the specified format also needs to be provided to the exchange. Further, all such listed entities need to review their credit rating at least once a year by a registered credit rating agency with the SEBI. Regulation 56 provides for the documents that needs to be submitted to the debenture trustee. So accordingly, listed entity needs to submit its annual report, auditor's certificate on fund utilization, notices and resolutions of the meetings held, and details of the meetings of the holders of non-convertible debt securities to the debenture trustee. Further, intimations regarding revision in rating, default in payments, or repayments or creation of charge also needs to be given to the debenture trustee. The company needs to submit a half-yearly certificate regarding maintenance of security cover and covenant compliance to the debenture. Further, any material events and information that has been disclosed to the exchanges by the entity also needs to be submitted to the debenture. Regulation 57 provides for submission to the stock exchanges within 1 working day of the status of payment of interest, dividend, or repayment of the principal or redemption of the security. Regulation 58 provides for compliances that needs to be made towards the holders of non-convertible securities by the listed entity. So companies need to send soft copies of the full annual report to holders who have registered their email IDs with the RTA. They need to provide hard copies of the salient features and full reports to unregistered holders upon their request. Further, notices of the meetings and proxy forms to holders of non-convertible debt securities needs to be provided. Ensure provisions for proxy appointments as per the Companies Act 2013.
Alifia, I wanted to take a moment. I think then it will be a little late if I just mention this. If we can move back a little bit more to the security creation slides. I think prior one. Now, security cover is a very important part of the entire debenture issuance process. You are required to keep 100% minimum or 100% plus security coverage to the to your debt debentures. Now, this entire process of security covenants or the coverage in the subsequent slide, Alifia has also mentioned that on a half-yearly basis, a confirmation with respect to the security creation is again also required to be given to the debenture trustees required to carry out that due diligence. Interestingly, what we've seen is now SEBI has mandated a platform to be created by the depositories in order to monitor the security covenants and other aspects. Now, we as company secretaries, we've suffered, I mean, not really suffered, I'll say we've transitioned from V1 to V2 and the version changes of MCA. We are facing the same with the with I think depositories as well. There again, we are required to file all of these details of the security covenants and monitoring that you've made the filings with ROC, the charge-related filing, and what was your security-related details. And this in turn has to be validated by the debenture trustees on the platform which the depositories have created. Additionally, the depositories have to confirm to the board, the SEBI board, SEBI about the compliances that the issuers and the debenture trustees have carried out. The entire gamut of regulations, if you see, is so very well maintained through their DLT platform, such that all of the involved authorities or the entities, that is the depository, the debenture trustee, stock exchange, and the SEBI is well informed that an entity, when it is borrowing, is ensuring that the security is created and all the covenants that were there are being monitored. We are still struggling, as a matter of fact. As and when the system settles down, I'm hoping things will be more easier. But really appreciate the way the regulator has been monitoring this bit. While we said that debentures is more easier to perhaps raise funds, but all of these checks are kind of keeping everybody on toes, all the entities involved as well as the issuer. So just wanted to highlight that bit. And I understand the pain of all the professionals who are going to issue the debentures with these platforms until the time they settle down. So yeah. Over to you, Alifia.
So we move forward to Regulation 59 of SEBI LODR regulations, which provides that any material modification that has been done to the terms of debt securities or redeemable preference shares requires approval of the stock exchanges, board consent, and approval from 75% of the security holders. The company needs to provide remote e-voting facility to the holders to consent to any such material modification. Regulation 59A provides for the scheme of arrangement that the company may be having. So a company needs to file the draft scheme of arrangement with the exchanges for a no objection letter before submitting the same to the NCLT. The no objection letter needs to be submitted to NCLT when it is seeking an approval of the scheme. It is also required to submit the documents to the exchanges post approval by the NCLT. So a listed entity needs to follow the provisions of Regulation 59A, though it may not be covered or equity listed. So even if it is debt listed, the necessary disclosures needs to be made to the exchanges. An important Regulation 60 provides for record date compliances and the requirements to submission of notices. A company needs to fix the record date in compliance with Regulation 23 of the SEBI Issue and Listing of Non-Convertible Securities Regulations 2021. Further, it needs to notify the recognized stock exchanges at least 3 working days in advance about the record date that may be fixed for issuance of such security. Regulation 61 provides for the obligations of the listed entity towards payment. So, entity needs to ensure timely payment of interest, dividend, or redemption payment for non-convertible securities and non-convertible redeemable preference shares. It cannot declare any or distribute any dividend if it has defaulted in such payments. Securities should be redeemed on a pro rata basis or by law unless specified otherwise in terms of the issue. So this is very important obligation that has been cast on there has to be no default, otherwise the entity cannot distribute dividends. Regulation 61A provides for unclaimed securities and benefits. So if any interest or redemption amount has not been claimed by the investor for a period of 30 days, then it needs to be transferred to an escrow account. An escrow account needs to be maintained by all the entities for the same purpose. Any amount lying unclaimed for a period of 7 years or more needs to be transferred to Investor Education and Protection Fund. Regulation 62 provides for the website disclosures to be made by the listed entity. A listed entity, debt listed entity needs to maintain a functional website with information relating to its business, the composition of its board and the committees that it has formed, the financial results and the annual reports of the company needs to be updated. Further, it also needs to provide the contact details for resolution of any grievances of the investor. Information on non-convertible debt securities and their status also needs to be uploaded on the website. Disclosure of interest, redemption, default, or failure in asset charge creation needs to be uploaded on the website of the company. Other information that requires to be stated are credit rating obtained, the deviation from the utilization of the funds, and the annual returns of the company. In furtherance, the disclosure requirements, Regulation 62(1)(a) provides for disclosure of composition of board, independent directors' terms, the code of conduct, the whistleblower policy, the non-executive director payment criteria, secretarial compliance reports, and related party disclosures, including the familiarization programs for the independent directors conducted by the listed entity. Regulation 62(a) provides for listing of subsequent issuances. So all non-convertible debt securities issued after January 1st, 2024 needs to be listed unless they are secure. Outstanding securities. Entities must have listed their unlisted securities before January 1st, 2024 within 3 months. The exemptions have been given to bonds, securities under multilateral agreements or court orders which have been exempted from listing. So, Deepika, we understand that SEBI LODR provides for comprehensive disclosures to be made by all the entities who have listed their securities. In fact, depending on the quantum of debt securities issuance, I think 500 crores and above entities have been classified as high value debt listed entities and they need to comply with the corporate governance regulations too. So comprehensive disclosure requirements ensures the safety of the investors as people place more reliance on the companies which have listed their debt securities, right?
Absolutely, Alifia, rightly put. Um, the first of all, to talk about the high net worth entities who have raised more than 500 crores are required. They are as good as an equity listed entity. They're required to have all the compliances which an equity listed company has to follow. Whereas entities with 500 crores, less than 500 crores of debt listed, they have some amount of lesser compliances to follow. But Chapter 5 in nutshell talks about all the compliances which you kind of covered in terms of disclosures, in terms of dissemination of information to the stock exchange, record date. I mean, you also have to be mindful of the fact that not intimating to the stock exchange on time attracts penalty now. And had it been a question of only a 10,000 rupees penalty payment, then I think we would have been more comfortable in doing that. But there was a time when stock exchange actually wrote to the entity saying that pay us this penalty and take it to your board. Now, as professionals, yeah, obviously you would never want to pay any kind of penalty or charges to the to the stock exchange. But given a scenario, you have to take it to the board. You have to be all the more on your toes. So all of these disclosures, record date, payment, interest, are very minute ones. At times when your debenture holder is only one investor, and debenture trustee is also monitoring you, and you will make sure that you achieve all those compliances. But a small oversight, because debenture trustee is looking at it, and we kind of overlooked a record date payment. So we've come across situations where it was easier for us to intimate the record date payment for interest, but the same date happened to be a principal repayment also, and we missed mentioning under the record date. That kind of a situation really puts us into a lot of difficulties. My limited point is, whenever you are issuing debentures, make sure you make a small list of it and ensure that these kind of lapses do not happen. They're very minute, but we have to be very careful. That's the point. But again, putting all the disclosures, putting it on the website is kind of gives the investor also a lot of comfort, as you rightly pointed out. So yeah, that's true. Those 2 cents from me. Yes.
Yeah, one is rightly you said very clearly. It's the professionals how to work with the checklist. Really speaking, because if a small things is actually missed out, it is actually going to cost a lot. So that is the thing, because we should not create embarrassment to our directors of the board, etc. Other thing and all. One has to thorough, one has to work. So that actually throws a lot of responsibility on the professional who are also going to be audited both actually. Yeah. Yes, Aflia.
Yeah. So we move forward to regulation RBI Master Directions 2024 for commercial papers and non-convertible debentures of original or initial maturity for up to 1 year. So RBI Master Direction specifically provides for entities which can issue such commercial papers or NCDs, which include companies, NBFCs, including HFCs, InvITs, REITs, AFIs, and other corporate bodies having a minimum net worth of 100 crores. Further, cooperative societies and LLPs with a minimum net worth of 100 crores, subject to their fund-based facilities being classified as standard at the time of issuance, are also eligible for issuing such securities. Further, RBI also has the powers to specify any other entity which can comply with these master directions. Eligible investors into these NCDs and CPs are residents who are free to invest in both the CPs and NCDs. Non-residents can invest within the framework as provided under the SEBI Regulations. The restrictions which have been specified are neither residents nor residents can invest in CPs or NCDs which have been issued by related parties in both the primary and the secondary market. The provisions related to primary issuance are CPs and NCDs must be issued only in demat form by the entities with a SEBI registered depository. The minimum denomination for such issuances are ₹5 lakhs and multiple tenor. The tenure for the CPs have been specified under the directions to be minimum of 7 days and they can extend up to 1 year. For NCDs, the tenure needs to be minimum 90 days and maximum up to 1 year. The restrictions which are further provided for such primary issuance of CPs and NCDs are no call or put options needs to be provided to the investors. Further, underwriting or co-acceptance are also have not been provided for issuance. Offer documents needs to meet the minimum disclosure requirements that have been provided as annexure to these master directions. The settlement has to be within T plus 4 working days, and the individual subscription has been limited to 25% of the issuance. The discount or coupon rate has been provided for CPs at a discount, can be issued at a discount to face value, whereas NCDs can be issued at discount, fixed or floating rate coupon. Floating rate NCDs needs to follow link to the benchmark approved by the Financial Benchmark Administrator FIMMDA and RBI policy rate. The credit enhancement provided by the banks and AIs by standby assistance or credit enhancement as per RBI guidelines needs to be maintained. Further, group entities can offer unconditional and irrevocable guarantee, and minimum credit rating of A3 needs to be obtained by such entities as per the SEBI guidelines. Master Direction also provides for the end use of the funds that have been raised through CPs and NCDs. Such funds can be used to finance current assets and operating expenses. Further, any other purposes must be disclosed explicitly in the offer document. The CEO or CFO of the entity must certify the end-use compliance and submit to ITA within 3 months or at maturity. Appointment of ITA and debenture trustees for the NCD is mandatory. Issuance must comply with board-approved limits as is mentioned under the various provisions of the Companies Act, and the regulator may also provide for the limits for such issuance. So, Deepika, any further compliances you as a financial entity is required to make under the RBI Master Directions specifically?
Yeah, so the regulations, as you rightly covered, this is in specific to the securities, the NCDs, which have the maturity value of less than 1 year, up to 1 year rather. RBI has a specific set of regulations for NCD issuances beyond more than 1 year. So there are 2 sets of regulations which RBI has issued, and you rightly covered on the CPs and the NCDs, which has maturity value up to 1 year. And because these are very short-term securities, these are highly monitored. Whereas the RBI regulations, when we refer to the regulations, is a very truncated version for NCDs which has a maturity value above 1 year, and they are broadly, so it brings in the reference to the company law and the SEBI regulations for compliances. RBI doesn't mandate too many compliances over there. It's a very truncated version. Versus what we are now looking at, where you rightly pointed about end use of funds, primary market conditions, etc. These are more highly monitored as compared to the others, where RBI looks at the entities to comply with the company law provisions.
Deepika, we have already checked upon debenture trustee roles and everything we have discussed in detail, but RBI Master Directions provides for IPA, issuing and paying agents. So how important are issuing and paying agents to the entire issuance of debt securities?
So, Alifia, this is a transaction which we've not really gone with too many transactions out there, but registering, and this is another authority. I think I'll lean to you all to talk more about IPA because IPA is something that we've got a very limited exposure on. I'd like to hear it from you all as well.
So IPA is basically what we understand from the directions are the banks which are there for making necessary payments to the investors and everyone. So when foreign investors are involved, so they are basically involved in that. So the company needs to have a proper appointment of IPA who is going to undertake the entire transaction. So as the debenture trustee provisions, it also provides in brief what compliances needs to be done by the IPA. So I think for Master Directions, RBI Master Directions, the role of IPA is also equally important. along with the debenture trust.
Okay. Yeah, well noted, Alifia. I think, yeah, that was a point to be noted here.
So we move forward towards secondary market trading and settlement. The CPs and NCDs can be traded either on the OTC or on the stock exchanges as may be approved by the RBI. The settlement timelines have also been specified in the directions. For OTC trade, it needs to be T+0 or T+1. And the CP's delivery versus pay basis via clearing corporation. So, as opposed to delivery, the payment has to be made simultaneously. The NCDs can have bilateral or DVPs via clearing corporation. Further, the master directions provide for buyback of such CPs and NCDs. So, buyback of them is permitted before the maturity. CPs can be bought back by the NCDs after 7 days of their issuances and NCDs after 90 days. So, the minimum tenor is blocked for both CPs and NCDs. Offers must be uniformly available to all the investors at market rates, and buyback details must be informed to IPA and debenture trustee for NCD. It also provides that the repurchased CPs or NCDs needs to be extinguished on the buyback date. So primarily we can understand the buyback provisions of the Companies Act needs to be complied in these cases also. For the repayment of CPs and NCDs, no grace period is provided for the repayment, and the issuers must provide redemption funds to IPA by 3 p.m. on the due date. So specifically, they have provided and mandated the companies to provide them such funds to the IPAs on the due date. In case of default, the issuers must notify the IPA or the debenture trustee by 5 p.m. on the default date. Public disclosure is required to be made by the issuer on its own website and the abstract platform. Defaulted payments routed via IPA or debenture trustee or directly to the investor. Issuers are barred from issuing CPs or NCDs until full repayment has been made or up to 6 months post such default. Here in nutshell, reporting requirements for CPs and NCDs have been provided. So for primary issuances, IPA must report all issuances on the abstract platform by 5:30 p.m. on the issuance day. For the secondary market transactions, all OTC and stock exchange transactions must be reported within 15 minutes of their execution on the abstract by each counterparty. For buyback, IPA must report buyback details on abstract by 5:30 p.m. on the buyback date. In case of default, the reporting of such default instances and the repayments must be reported by the IPA on abstract by 5:30 p.m. on the default or repayment date. The depositories must report dematerialized CPs or NCDs to RBI fortnight, 15th and the last day of the month or as may be directed by the RBI. The outstanding NCDs and the details of the default must be reported quarterly, that is within 15 days of the quarter end, to RBI via email by the debenture. That's it. Thank you.
Right. Now, Mr. Bala, we can take the questions.
Yeah, we can take the question, number one. Number two, Ophelia, you have very nicely put up everything in a very, very lucid form on this complex subject, actually, which I must tell you. Really, you have done a wonderful job. Let us go through the process now. You are talking about the meeting of the debenture trustee. Is the meeting is mandatory or it is only when it is required?
We're saying meeting of the debenture trustees.
Yeah, I think so. Because initially the question has been put whether the meeting is required or it is mandatory or it is only as and when required. That is the question.
Typically, a debenture trustee is one for the issuance unless more than one debenture trustee is appointed. So the concept of meeting may not really be very relevant, considering debenture trustees are required to monitor the transaction and its compliances on a very regular basis. The company is required to submit a half-yearly compliance status to the debenture trustee, which means it is kind of monitoring it on a very regular basis. So the probably the question of debenture trustee meeting is probably not very perhaps redundant. Alifia, any views here?
I think
No,
probably
for debenture holders, meetings may be held.
yeah, debenture holder meeting may be held if it is required. That will be the case, I think so. Because if there are any issue which is affecting for the debenture holder, then in such a case, depending upon the issue, debenture holders meeting may be held. I think so.
Yes, because their consent is needed when any changes have been made in the material terms of debentures.
Correct. That's right. In case the fund is actually dispersed, is made in tranches, do we need to issue PAS 4 for every time if the fund is dispersed, or one-time PAS for the entire amount of the sufficient?
Seems like a very practical question. Alifia, you want to answer? I've seen a situation where the funds are raised at one go. So there's one PAS 3.
So whenever funds are given or raised in tranches, every time PAS 4 needs to be issued, but there may be cases where funds are being raised from different investors. So PAS 4 needs to be approved, and every time offer needs to be made to the investor for him to subscribe to the debenture. So necessarily PAS 4 needs to be approved.
Yeah, Mr. Bala, next question.
Yeah, can you please explain the difference between the debenture issue and a convertible note under the Companies Act and its relevance? Difference between the debenture issue and convertible note under the Companies Act and its relevance.
Convertible note, I think, appears in NCDs in itself as a security. Convertible note is rarely used. Again, that's also that has certain limits of 50 lakhs and more to do with government schemes. That's where I have come across when it comes to convertible notes, the CNs. NCDs are your regular kind of a security, which is
Raised by the company.
yeah, that's my thought, but happy to learn it more about convertible notes.
If we can also kindly throw some light on the green bonds, if possible, although it is not the subject for discussion of today's meeting.
I think it will be, I'll leave it to panel, but it is out of the topic.
Yeah, that is true.
And we can go to next question.
Yeah. Okay. I think, sorry, this is the deviation of the topic. Can a private company issue CCD through the right issue?
CCD is
If private company can issue a CCD private issue, I think he's touching upon the section 62 subsection 1, I think so. I don't think a private company, they cannot issue the compulsory convertible debenture through the right issue. I don't think so. Because I think if we look at the section 62, it prohibits the issue of the debenture through the right issue. That's what my understanding is there. Afilia, you can say on this.
Yes, sir, rightly said. Private companies cannot issue CCDs through rights issue. It is more of a equity share and convertible shares which may be covered under, which are covered under section 62 of that.
Yeah, correct. Because I think, if I'm not mistaken, 62 subsection 1, I don't know, further subsection is there, it categorically prohibits the issue of the debenture through the private right issue. Yeah. Can you please answer the question whether the unsecured debentures are allowed to be listed?
We have already discussed it.
We already discussed if it is listed, it is there. If it is not listed, it will attract the deposit. That's what we already discussed actually. Yeah. Can an unlisted company, being a NDCS and issues convertible note, whether it can be treated as a deposit by that NBFC?
Get that question again, sir? I think again the reference is to convertible note.
No, unlisted company being a NDCS and issues the convertible note, whether it can be treated as deposit by that NBFC.
I think it is.
Convertible securities are not covered, are not treated as deposits. Only non-convertible securities which are being issued without any security, we can say they fall under the deposit. Deepika?
I think so, yeah. I mean, what they're referring to is an NBFC which is not accepting deposits, which is normally the category of NBFCs. If they are accepting securities, it's in continuation to the same question which you clarified earlier, saying that when is it to be treated as a deposit? So it's not about non-deposit taking or a deposit taking NBFC.
Either a chance where the debenture holders have lost their money along with the interest.
Yeah, there are. And the cases are also filed.
I think cases have been actually reported, but we don't want to touch upon a specific thing, but there are, yes, it's are there.
And I mentioned only that, that debenture trustee filed and it took to liquidation and no one has received and all that.
Optionally convertible unsecured debentures. Many companies are found to be issuing optionally convertible unsecured debentures to the companies. They actually should be valuation report mentioning that the valuation would be done at the time of the conversion.
Mr. Bala, that they avoid the valuation report mentioning that the valuation would be done at the time of conversion.
At the time of conversion.
If
conversion happens, they further claim that the deposit rules are not applicable to them because they are actually issuing the companies which falls under the category of the exempted deposits. The act is not defining the mentions of the term optionally convertible debentures. In the process, they provide virtually interest-free loan to their group companies. Is it permissible?
Valuation is for convertible. No? It's optionally when converted. It's not that when there is a proper regulation that if you are issuing any optionally convertible, then what will be the formula and all that. Yeah, sorry, panelist.
I think that question from somebody who's working as a company secretary for a company will not look out for the loopholes like this to understand how we can issue them and an optionally convertible debentures. We would always want to go in a straightforward format of issuing a non-convertible debenture. So hence I was curious to understand if somebody's faced this as a very practical question and if they've faced any repercussions from any of the authorities. Definitely an NBFC or a RBI regulations will not allow us to issue a security of that kind, which is optionally convertible security, and then say that there's a valuation report in place. I think I'm not even in a position to really answer that question. But practically, ma'am, if you all have seen a client who's coming in with this kind of a question, I'm wanting to understand more, but I don't think that's something that one can do. That.
Yeah, client comes up with this kind of thing, but then we say that at the time of actual when you are there, question, it will create an issue because it's structuring you do, but there are authorities which will be questioning, so it's a risk you take because it will be termed as a loan or deposits or any kind of thing, and the valuation is not done. It's a questionable transaction since you can't take the liberal view of interpretation because you yourself here in the question predicting that this is you are knowing that it is not correct thing they are doing. Like others, the regulator will also question. So we as a professional advice, but still if the company take a risk, what to do?
Can I get the copy of the material and the recording of this information? Yeah, recording will be available. It will be disseminated via the YouTube. You can always access it. There's no problem. After the webinar, it's that is right. Great information. NCD cannot be issued more than 1 year. Is it correct?
They can be issued.
What are the conditions for more than 1 year?
Like we've just discussed, I think we spoke about it. I'm kind of specifying a little bit more on the RBI regulations, but you can issue of different tenure. maturity can be up to 1 year, maturity can be up more than 1 year. The regulations are slightly different. When you're keeping the maturity to be less than 1 year, there are different kind of risks attached because it's a short-term security, different kind of regulations that attract. But from a Section 71 and Rule 18 and our SEBI regulations perspective, the requirements remain the same, other than what we spoke about the regulations which Alifia detailed out about the IPA, debenture trustee also being appointed because it's a short-term security. Yeah, in case that answers the question.
CCD is the kind of hybrid security. So can we connect that way? I'm actually not getting it. What exactly is this? CCD is the kind of hybrid security. So can we connect that way? I'm not able to get it actually.
The hybrid.
Features of securities, but
yeah. What are the rules and regulations for a NBSE to issue NCD? Also, is it going to be secured NCD? How much will be the cost incurred, please?
I think the entire discussion that we've had revolved around the same aspects, which rules apply, what kind of costs we'll be incurring, etc. I think it also depends on the kind of quantum that you are raising. That's your cost. You pay to the stock exchange.
Debenture trustee, whatever agreement you enter with the debenture trustee, and everything has to be taken care of, including the security cover.
We discuss unsecured debentures. Can we actually list that question is whether it is permitted? To my knowledge, unsecured debentures are not allowed to be listed at all. So it can never be listed. They are actually considered deposit. So do we agree that only secured debentures can be listed?
No.
Yeah, panelist, or we can go ahead.
Yeah. Can you explain what is the exact difference between Section 42 and Section 62 1C? Maybe it is very basic, but it will be beneficial to the many professionals. I think we started with a masterclass sessions of this Companies Act. We actually talked very first topic, if I remember correctly, Section 2, definitions and the interpretation of the law. That is what we are asking. I think the professional has to go through, they'll have to interpret the law correctly. This cannot be the things, cannot be asked here, what is the section, what is the thing, according to my view. Because we being a professional, we will have to actually interpret correctly, we'll have to read. That is what we started with actually very first session itself, we talked about this. Am I correct, Dipti?
Yeah. Yeah. Means actually we'll request that this kind of section difference, since now we have not made, if panelists want, but it will be difficult for us suddenly, but the section difference one can work out.
Okay. Optionally conversion difference, how the interest is paid to the convertible debenture.
How's interest paid? I think that's the feature of it. I mean, your debentures are the a security where interest payment is to be made. I'm not sure what question really meant here, but whether it is a non-convertible or a convertible debenture, the important feature of it is the interest payment. Again, depends on what your interest periodicity is going to be, annual, quarterly, monthly. The interest payment will be a standard way, the way you do it for any other.
Yeah, it is according to the terms and conditions of the issue of the debenture. That is what I think. So, because terms and conditions, when you actually talk it, it will take care of the things. What is the terms and condition? According to that, it will operate. I think so. Is CS is required to be appointed under the NCS rule or LODR for a private debt listed company?
So for under regulation number 6 of LODR regulations under chapter 3, chapter 1, I'm missing on the number, appointment of a compliance officer is essential, and a compliance officer indication there is a CS. So yeah, you will require a CS if you're issuing a non-convertible debenture and your getting it listed on the stock exchange.
Interest paid on the regular period, depending upon the terms of the issue, that is right. Debenture trust is mandatory for a private limited company if value is, what is that, over and only one debenture. Debenture, yeah.
So I think appointment of a debenture trustee, face value of 1 lakh can be the value of the debenture, but the quantum of your issue can be larger. And debenture trustee, even if there is a single investor there, debenture trustee appointment is mandatory to my understanding. But I'd like to
debenture trustee is a must actually. Without that, there is one or many that immaterial, debenture trustee will be required when you actually go for the debenture. Yeah. I think that's all the questions. I think there's one thing is there. Is SDD is mandatory in the debt listed private company?
It is. I think that's a very controversial question. If Alifia wants to take over, I'll be more than happy, but we've struggled with it. We also tried to understand as to why should we be complying with SDD, but we've heard it from Sudhakar sir also, so I want to give that credit to sir. He's conducted a very nice session and helped us understand that whether your debt is listed or your equity is listed, you have to equally comply with these regulations. And so
PIC regulations are applicable to both equity listed and debt listed.
Correct.
Absolutely, I agree with you. Sudhakar has actually explained that very correctly. That is right. Yeah.
Yeah.
That is all. I think with that we have completed the questions actually. If there are anybody who would like to raise the questions or something, they can raise their hands and we can definitely take up those questions. As of now, there is one hand is actually risen. Sorry, rather 2 hands are risen actually. Yeah. Only there's Srinivas. Srinivas, are you there? Other is actually Gaurav Sharma. Are you there? Gaurav? Srinivas?
I think it's by mistake. It's from starting the raise his hand.
Okay. Yeah, there is one more hand. Now Srinivas is there. Yes. Yes, Srinivas. You can unmute yourself. You can speak. Yes, Gaurav. You can also unmute. You can start. Any one of you.
Mr. Gaurav said by mistake. It was.
Okay. Srinivas?
Yeah, from my side also it's by mistake.
Okay.
Okay.
It is one more question. Is it necessary for all debentures, debenture securities to be listed on stock exchange? We discussed that it is not necessary. It's your option.
Yeah, that is right. Listing is your option. Yeah.
Yeah, the certain people have said there are many issues of optionally convertible debentures are issued. Yes, we know that optionally convertible debentures are issued. The question was that what was issue? Question was that valuation report not to be taken at the time of issue and just taken at the time, not at all taken during the entire tenure, and when it will be done only when the debentures are converted, if converted, since it's optionally. So there we were discussing whether that kind is correct interpretation or not. So we were telling that since it is a convertible debentures, it should be there. And if you don't do it, if the interpretation as a regard valuation should be conservative, that we are talking. Okay. Anything else? Otherwise, we can close today's webinar.
Yeah, that is all. I think so. There is no more hand risen and there's no more questions also.
Yeah.
There's somebody is asking one question. I think so. Can an individual, not from the institution investor, trade in NCD by sell?
That is possible because there are market linked debentures again. So if I take an example of our own the company where I've been associated with, there are individuals who are trading in the debentures. So yes, it's not just the MFs or the entities, but there are individuals also who trade in the debenture securities.
I think, Dipti, we can close now with this.
Somebody has asked, Namita has asked, says very Namita always, what is the benefit of listing of debentures?
So the investor confidence is the main benefit of listing of debentures, because investors have the confidence since the company is complying with all the regulations, the disclosure requirements and everything. So it gives a confidence level to the investor.
See, not only that, a company's reputation goes up, company's image goes up, it gives a greater confidence to the investor, and the compliance requirement is actually met with. So these are all various things which is coming in both the sides. Actually, investor get a confidence in the company deal with, at the same time, company also create the reputation of its own.
Yeah, Deepika, your view on the topic?
Again, rightly put by Sir and Alifia. Also, the fact that it gives an easy exit makes it comfortable for, in case, like I said, if there are market-linked debentures, it's easy for you to sell off the securities like the comfort you have with equity-listed entities. That's another advantage. There can be a change of hands. Somebody else can come in as an investor.
Somebody has actually put, in case of the inorganic acquisition.
It doesn't look like a question, Mr. Bala. It looks like a point he is telling. You can read it still.
Okay. In case of the inorganic acquisition, the outstanding debenture are being sold at ₹1 value. In that case, the difference between the book value or the debenture value ₹1 to be credited to the capital reserve.
I don't know. It's a question. You can take next.
If a company listed the debenture, whether that company will be treated as a listed company?
We discussed.
Of course, of course, whether it is a debenture listing or equity listing, it is ultimately a listed company. Only thing is, we will have to comply with the LODR regulations, which are applicable in both the cases. If there are debenture holding, partner required to be filing quarterly.
Is there a debenture holding pattern, I think, required quarter?
Okay. Liquidity for investor provided by the listing NCD. Okay, there is of course answer. The buyer company comes to this till such time. Yeah.
I think we can close the session now. It is over.
There is one hand is risen by Rajiv. Yes, Rajiv, if you are there, you can ask the question. Are you there, Rajiv Bhatia?
Yes, I am there, sir. My question is, till the time the acquirer company, the buyer company carries this balance of capital reserve, and once it decides to pay, once the cash flow is regular, the buyer company decides to pay back the debenture holder. In that case, it can offer to tax. I mean, I'm just trying to corroborate this information to the actual practice. So I just want to know the experience of other panelists. Is there any other way than this? Because till such time I carry this capital reserve in my books. So will there be any questions or any queries from the tax department, the income tax department?
Deepika, would you like to comment?
Income tax provisions, I'm not very sure, Rajiv. But then I think when you started off with the question saying the company is under a takeover and the new investor would like to have the NCDs paid off. Is that how? Is part of the question?
It is actually the debentures which are carried at a value of ₹1 instead of the book value, and therefore there is a equivalent amount of capital reserve in the books of the buyer company, which will be carried till the time the buyer company generates enough cash flow and pay back to the debenture holder. So is there any exposure from the income tax department in this treatment? That's what my question is.
From an income tax angle, perhaps, at least I don't think I will reserve my answer. I wouldn't be able to really comment on that part. But in fact, the entire transaction need to be structured considering there's a takeover. And
Yes.
you will the entity taking it over will have to be bound by the transactions that you would have signed with the investor
Right.
for NCDs. You will
Yes.
either roll out, or you will continue to hold it as any other security and keep continuing to pay the interest. But
Correct.
the other aspects which you are trying to structure in terms of capital redemption, etc., I think it's a tax consultant who will be better placed to answer. At
Okay.
least I'll reserve
Sure.
myself from answering this question.
Sure. Thank you.
I think Abhishek wants to raise some question.
Yes, sir. Good afternoon, everyone. My question is, ma'am, what is the role of practicing company secretary in the process of listing of debt securities on the stock exchanges?
Alifia and Deepti ma'am would like to answer that because you're practicing company secretaries and you've been helping us a
Yeah.
lot. So I think we'll park it to you.
Basically, see, like listing of shares, the debenture listing also has process, disclosure, documents, all that to be carried out, key information. As she rightly mentioned, that there are so many details you have to give. So depending that support function we can do, and like we support them corporates for equity listing, we can surely do that same thing, and also providing them inputs and requirements, keeping in mind different regulations. That all we can provide the supporting function.
Okay, ma'am. Got it. Thank you so much.
So starting on here, I think while we've been working on the GID, key IDs as the company professionals, we always place one step more reliance on the professionals like you all, who will look through our inputs that we've put in and give a perspective as to how well this thing can be documented, because these are such an elaborate document that sometimes it's difficult for the in-house counsels or the company secretaries to give complete justice. So the support from a practicing professional really comes very handy and becomes very important for us to seek. Yep.
The capital reserves and income tax relation, somebody has put a comment actually here. The capital reserve reserve is a capital item, is the appropriation of the profit after tax. It does not give rise to any income tax. That's a comment which has been actually made. Yeah. Yeah, that's all I think so, Dipti. I think we have answered all the questions. No more hands are risen actually.
Yeah.
So I think we can close the session here.
Yeah, thanks, Alifia. Thanks, Deepika, for your inputs. Thanks for taking through the entire topic, answering all the questions, sharing your knowledge, and all the participants for all your participation, questions. Thanks a lot. Thanks a lot. Thank you, Mr. Pala.
Thank you very much, Deepika. Many thanks for your taking of your time answering our question. Many thanks to you. Look forward to you in our summer.
Yeah, thanks a lot, everyone.
Thank you.
See you next week. Bye.
Future sessions as well. Thank you. Yet another session.